I want to revert back to the fifth seating in the election date. So I'd ask Mr. Ford and Mr. Hernandez, Mr. Messenger, Ms. Bund, Mr. Sharma, and Mr. Friedman to take your places, and I appreciate your indulgence. Mr. Ford, you may proceed.
Thank you, Mr. Chairman. Martin Hernandez will speak first.
Okay.
Thank you. Thanks for the opportunity to speak again in support of the board's proposal.
Good. Mr. Hernandez, can you bring your mic a little closer?
Sure.
Thanks.
As a union organizer, my point of view is that the board should schedule elections as soon as possible. I would love to see elections held 10 days after the petition is filed. I believe that most workers, no matter where they stand about the union, they also want their election as soon as possible. It normally takes about 42 to 45 days to get an election if we sign a stipulated election agreement, and longer if we have a pre-election hearing. 42 days is way too long. Most workers get very stressed out before an election. In my experience, the main reason for this is that many companies bombard their workers with a scary anti-union propaganda about what might happen if the union wins. For example, in one recent campaign, the company set up monitors in the workers' break rooms and in other areas where workers congregate. For a week and a half before the election, the company continuously broadcast anti-union videos. The videos were so negative and included misleading information. Several workers talked to me about the videos and were so disturbed by what they saw and heard on these videos that they were crying. Workers, they should not go through this painful process, in a campaign day after day. We recognize that the rule requiring elections within 10 days or even as soon as possible may not work in every case. So, Local 99 and I support the board's proposal to hold elections as soon as practicable. But the language should be explained. Specifically, the rule should require elections within 15 days after the petitioner receives the exception list, unless the parties agree to a later date. Although petitioners can waive the right to have the list for at least 10 days. I am unaware of Local 99 ever doing that. Regional directors should not be allowed to schedule an election any later. If an election can be held on the employer's premises between the 15 days after the petitioner gets the exception list, the regional director should direct a timely mail ballot or off-site election. There should be no minimum time period between the petition and election. Employers can inform workers of their anti-union views whenever they want. Most companies, they start campaigning once they learn of our union organizing activity, and that's usually long before the petition is filed. Just to give you an example, another example. A few years ago, Local 99 had an organizing campaign at a company that holds trash. By the way, this was a small employer with less than 100 employees. In our initial meeting with the workers, this happened on a Friday evening, as I recall. By next Tuesday, the company, they already brought in a union busting consultant, and they were calling the workers into captive audience meetings. The company's strong anti-union campaign scared the workers and caused Local 99 to suspend its campaign without even filing a petition. The employers, they already have enough time to do their campaign. They don't need any additional time. Thank you.
Thanks again for the opportunity to speak. I'm going to make 3 brief points. A lot of this has already been said in other ways, but first I wanted to reiterate that employers already can express their anti-union views to workers before there's an organizing campaign, and some employers actually do that. Walmart and Target are two examples of companies that show anti-union videos to workers during orientations. Secondly, most other employers start campaigning as soon as they learn of an organizing campaign. But even those employers who wait to campaign until the critical period would have ample opportunity to campaign if the board's proposals are adopted. If you count out the dates, there's going to be at least 7 days until the hearing. There's going to be at least 1 day before DD&E is issued, another 2 days before the Excelsior list is due, and then there's the 10 days that the petitioner can have the Excelsior list. That's 20 days. And of course, it can be longer. There can be special circumstances that would postpone the hearing. DD&Es often take more than 1 day to issue, and so forth. And finally, as Member Johnson alluded to, 8C doesn't strictly apply in our cases. Of course, the First Amendment does need to be considered, but there's nothing in either 8C or the First Amendment that gives any party the right to speak for any particular length of time. And finally, the proposed rule, I think it's obvious, but it should be stated, doesn't regulate campaign speech in any way. Thank you.
I just have a question for Mr. Hernandez, and thank you for coming to talk to us. In your experience with workers involved in organizing, do they, the sense you get from them, do you get the sense that they do not have enough information to decide whether or not they want to be represented by a union?
No, ma'am. As I said, I wanted to take the opportunity to say this. Also, the top 40 day, that's too much. Employees already got their information. They, unfortunately, and very unfortunately, that I have to say to workers that the only thing that they wanted to do is to improve their working conditions. I have to tell them that once we file the petition, the next 45 days are going to be the longest days and the most painful days of their lives. So, that's a shame that we have to say that to the workers.
Thank you.
Two quick things. One, thank you for keeping your 2014 comments very tight in terms of non-duplication. Two, do you actually have a position? It sounded like 20 days was around sort of the minimum bracket between petition and election, and it sounds like you have the position that 42 days is too long. Do you all have a position on what that should be, if there was a minimum maximum?
Well, we don't really think there should be a minimum maximum, but we do think that even under the proposed rules, in the most extreme situation, that there would be ample time for the parties to get their views out. And in most instances, that period of time during the critical period is going to be 3 weeks or more, which isn't all that different than the current situation.
Okay. Would it be fair to say that you don't think 21 days poses any problems for an employer getting its message out?
No, I don't.
Okay.